Welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today, based on the poll that I put out, 70% of you said yes, you want me to go through every single page of this defendant's motion to dismiss a complaint. The defendants are the Laundries, trying to dismiss the complaint, the lawsuit filed against them by the Petitos. So, as you know, I try to keep these types of document readings as interesting as I possibly can. I do like to deep dive documents like this, so I just wanted to gauge if you guys wanted as well. To the 30% who voted, no, this is boring, just skip this one. Or give me a chance, stick around and see if I can make this interesting. That's the challenge. I like challenges, challenge accepted. Let's see if we can read through this 20-page legal document and learn a little something new about the case. Of course, the fight is for justice for Gabby Petito, and that would be my reason for reading through it. So, if you're ready, let's get started. Okay, so we're starting on page 1. As I say, there's 20 pages. We're going to power through. I've got my water. I've rested my voice. Some of you were really worried about my voice. We're going to be okay. If you are not yet subscribed, please do hit the subscribe button and the bell so that you know when I'm next uploading, premiering, or going live. Here, you just don't know what's happening when unless you do that, because I just go live whenever. I cover cases. I deep dive. So as soon as the presentation is ready for you guys, I schedule a live stream, and I don't want you to miss out. Also, please leave your DNA on the thumbs up and leave a comment below. I love reading through your comments, even though I have no capacity to respond to all of them. All right, let's get started. So the filing number 146739896E filed on the 30th of March 2022 at 4:01:48 p.m. in the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, state of Florida. Joseph Petito and Nicole Schmidt, plaintiffs, versus Christopher Laundrie and Roberta Laundrie. Thank you also to a Grizzly called Cheryl for sending me this document. Thank you so much. Love it when you guys send me documents. Also, shout out to my YouTube members and all my patrons, Buy Me a Coffee supporters, PayPal supporters, merch buyers, book buyers, and everyone who supports the work that I do. I really appreciate it. Okay, so defendants motion to dismiss the complaint. They say, comes now. It feels like Shakespeare. Comes now. Hitherto. Okay, comes now. The defendants Christopher Laundrie and Roberta Laundrie. The Laundries. I like how they put that. By and through undesigned counsel, and hereby move to dismiss the complaint pursuant to Florida Rule of Civil Procedure Rule 1.14b for failing to state a cause of action for intentional infliction of emotional distress. For the reasons set forth below, there are no facts that could support this cause of action, and the court should dismiss the complaint with prejudice. I can just imagine Bertolino and the Laundrie saying that. They say, background. The facts surrounding this case have received widespread media attention, and the court is likely, at least generally, aware of the events that preceded the filing of this lawsuit. Hope so, right? They should be aware of it. The complaint alleges that the plaintiff's daughter, Gabrielle Petito, and the defendant's son, Brian Laundrie, were engaged to be married. Complaint. Ms. Petito and Mr. Laundrie were traveling in the western United States in the summer of 2021. At some point during the trip, Ms. Petito went missing, and there was a search for her whereabouts. Okay, she was murdered, but yes, let's read on. Shortly thereafter, law enforcement commenced an investigation which included Brian Laundrie and the defendants. The complaint does not allege when Ms. Petito was reported missing or when the law enforcement investigation of the Laundries began, but news reports indicate that Ms. Schmidt reported Ms. Petito missing to the Suffolk County, New York Police Department on September 11, 2021. Ms. Petito was found deceased in Wyoming on September 19, 2021. All correct, yes, and that was actually quite quick, right? Thank goodness. Sometimes it would take much longer, right? Brian Laundrie was found deceased in Florida on October 20th, 2021 of suspected unaliving oneself. Don't come at me for saying that word. It triggers the YouTube bots, and then all this hard work would be literally for nothing because the video would have no reach. I'd be instantly demonetized. It'll be like, whoa, why did I strain my voice for all this, right? So anyway, so that's why I say that word. 2. Memorandum of the law. The complaint should be dismissed with prejudice, and the plaintiff should not be granted leave to amend. Although leave of court to amend a pleading shall be given freely when justice so requires, FLA, so R Civ P 1.190A, leave to amend the need to be given where the amendment would be futile. Then they say Tuten versus Fariborzian. Don't know what's going on here. 84 SO3D 1063 1069 FLA 1st DCA 2012. A proposed amendment is futile if it is insufficiently pled or is insufficient as a matter of law. Armiger versus Associated Outdoor Clubs Incorporated, quoting a whole bunch of law stuff here, of course. Right, so the complaint is insufficient and deficient as a matter of law for many reasons, and those deficiencies cannot be cured by the amended complaint. The gravamen of the claimed wrongdoing is that the Laundries exercised their constitutional rights and essentially made no statements to plaintiffs or law enforcement. As a matter of law, the Laundries' silence conduct could not form the basis of a claim for intentional infliction of emotional distress. The Laundries' constitutional rights and the elements necessary for such a cause of action would not change with an amendment of the complaint. Furthermore, the time period at issue occurred several months ago, and the foundation of the plaintiffs' claimed distress, wanting to find their daughter, has been resolved. Damn. It's quite savage, huh? Like, it's over now, is what this is saying. Why are they complaining now? It's over now. Whoa. There are no more facts that could emerge that would bolster the plaintiff's claim. The plaintiff's failure to state a cause of action in the complaint provides ample basis to conclude that the plaintiffs would not be able to add the missing but required information if provided with another opportunity to bolster their allegations. As an amendment to the complaint would be futile, the complaint should be dismissed with prejudice. A. General pleading deficiencies. The plaintiff's allegations attempt to set forth a cause of action for intentional infliction of emotional distress. As an initial matter, the complaint's ambiguity and lack of separate statements and counts as to each plaintiff and defendant pursuant to FLAR Civ P 1.110F independently warrants dismissal for repleading. The allegations must be sufficient to inform the defendant of the nature of the cause against him. Dawson versus Blue Cross Assen. All right then. The defendants assume the cause of motion is one for intentional infliction of emotional distress because words relevant to the elements of that cause of action appear in the complaint. However, the phrase intentional infliction of emotional distress appears nowhere in the complaint. It is also possible that plaintiffs might be trying to allege a cause of action for tortious interference with a dead body, but it is not all clear. Maybe trying to allege a cause of action for tortious interference with a dead body, but it is not all clear. Florida Rule of Civil Procedure 1.110B requires that a complaint must state a cause of action, and if a complaint is so vague, indefinite, and ambiguous as to wholly fail to state a cause of action, it is a subject of dismissal. Frisch versus Kelly, 137, and a whole bunch of numbers. Plaintiff's complaint ambiguously draws language from two unidentified causes of action and does not identify either as the cause of action upon which it relies. That deficiency requires dismissal. The complaint is further deficient because it names two plaintiffs and two defendants without attempting to distinguish between them. The complaint offers no theory that would impute the conduct of one of the defendant against another, so any cause of action against them must be separate. The same is true of the plaintiff's individual causes of action. Commingling various claims against all defendants together may warrant dismissal of a complaint. They're quoting again from these sources. Similarly, each distinct plaintiff must maintain its own action to recover for its own loss. While these two pleading deficiencies require dismissal and could potentially be corrected by amendment, plaintiffs' legal theories are fatally flawed and could never be remedied by amendment, thereby requiring dismissal of the complaint with prejudice. Whoa. The complaint fails to meet factual pleading requirements. Pleadings must be something more than an ingenuous academic exercise in the conceivable. And a whole bunch of sources as well. Florida is a fact pleading jurisdiction. To withstand dismissal, a plaintiff must allege more than a naked legal conclusion. It is insufficient to plead opinions, theories, legal conclusions, or argument. The quality of pleading that is acceptable in federal court and which will routinely survive a motion to dismiss for a failure to state a claim upon which relief may be granted will commonly not approach the minimum pleading threshold required in our state courts. This is what everyone feared, is they're just going to toss it out because they're like, everything that was filed in that lawsuit was kind of emotionally driven, right? And here that's kind of what they're saying of the that's cute, but we're going to dismiss this. So I don't know. We'll have to see what happens from this. But anyway, let's continue. Florida officially recognized the tort of intentional infliction of emotional distress in Metropolitan Life Insurance Co. versus McCarson, which adopted Section 46 Restatement of Torts, 1965. To state a cause of action, a complaint must allege 4 elements. 1. Deliberate or reckless infliction of mental suffering. 2. Outrageous conduct. For me, I'm going check and check. Okay, 3. The conduct caused the emotional distress. Yes. And 4. The distress was severe. Check. Okay, but they're going to argue against it, I'm sure. Behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Check. My word. Okay. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. I think it was, but okay, carry on. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Even if a complaint alleges facts, those facts, if proved, must establish a cause of action for which relief may be granted. While the plaintiffs allege some facts, those facts could never establish a claim for intentional infliction of emotional distress because the Laundries' actions were legally permissible, constitutionally protected, not outrageous, and do not give rise to any cause of action. 1. The Laundries in action was not outrageous but legally permissible and constitutionally protected. Outrageousness is the threshold test for recovery in an intentional infliction of emotional distress claim. Whether conduct is outrageous enough to support such a claim is a question of law, not a question of fact. Okay, importantly, the standard for outrageous conduct is particularly high in Florida. That's a scary thought. It's got to be much higher than how outrageously the Laundries behaved, but okay. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice, or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. All right. And then, rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Generally, the case is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, "Outrageous!" I think it's a little more than that, but okay. The law is clear that a pleading is insufficient if it contains merely conclusions as opposed to ultimate facts supporting each element of the cause of action. Although the complaint alleges the Laundries' conduct was outrageous, the complaint's failure to provide factual support rising to the level of outrageous conduct makes that allegation nothing more than a legal conclusion. The essential allegations against the defendants are nowhere close to meeting the necessary standard. Those allegations are, without providing any factual support, the complaint states it is believed that Brian Laundrie told his parents that he murdered Gabrielle Petito. Christopher and Roberta Laundrie spoke to and hired an attorney on September 2nd, 2021. After September 1st, 2021, there was no contact between the Laundries and Joseph Petito and Nicole Schmidt. The Laundries went on vacation to Fort DeSoto Park from September 6th to 7th, 2021. Roberta Laundrie blocked Nicole Schmidt on her cell phone and Facebook on September 10th, 2021. The Laundries' attorney made a statement on September 14th, 2021. The attorney for Joseph Petito and Nicole Schmidt issued a letter to the Laundries on September 16th, 2021. The Laundries did not respond to Joseph Petito, Nicole Schmidt, or law enforcement. The Laundries instructed that all contacts be made through their attorney, who did not comment. The Laundries did not provide the whereabouts of Brian Laundrie, followed by the unsupported allegation that the Laundries were making arrangements for Brian Laundrie to leave the country, which is contradicted by the undisputed fact that Brian Laundrie was deceased. Oh boy. Complaint 29. And the Laundries could have alleviated the mental suffering of the plaintiffs by disclosing what they knew about Gabrielle Petito's location. Although the complaint makes several accusations about Brian Laundrie's conduct, he is not a defendant in this case, nor is there any legal theory that would impute his conduct to his parents. Well, okay. Wow. None of the allegations recited above, either alone or together, describe outrageous conduct. In fact, the complaint fails to allege conduct at all. Basically, the complaint alleges that the Laundries failed to have any contact with the plaintiffs when the plaintiffs wanted them to speak. That allegation falls so far below the particularly high standard for outrageous conduct that the complaint should never have been filed. The only affirmative statements alleged in the complaint were made by the attorney for the Laundries, which is entirely appropriate under the circumstances. Conduct claimed to cause severe emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. The Laundries' decision to exercise their constitutional rights to silence, privacy, and counsel, and to have the attorney speak for them under such trying circumstances and media pressure could not be further from conduct that is extreme or goes beyond all bounds of decency. It is what most people would and should do in such a situation and in a civilized community. The letter by the plaintiff's attorney, referenced in the complaint, even acknowledges the complicated conditions faced by the Laundries. We understand you are going through a difficult time, and your instinct to protect your son is strong. The plaintiffs cannot express sympathy and understanding for the Laundries' enviable position and then claim the Laundries caused them emotional distress by not responding in the way the plaintiffs desired. If the Laundries' act of doing nothing other than maintaining their privacy and silence is enough to subject them to this supposed cause of action, then there would be virtually no limitations on the tort of intentional infliction of emotional distress, and the fundamental right to remain silent under any circumstances would be obliterated. Labeling the Laundries' silence as outrageous is particularly incongruous with the context of the attempt to contact the Laundries discussed in the complaint. The only attempt at contact alleged is that the attorney for the plaintiffs issued a letter to Christopher and Roberta Laundrie asking for their help in locating Miss Petito. Because it would be a violation of Rule 4-4.2 of the rules regulating the Florida bar for the plaintiff's attorney to contact the Laundries, knowing the Laundries were represented by an attorney at the time, the plaintiff's attorney presumably did not send that letter directly to the Laundries. The complaint is not specific about how the letter was issued, whether through the mail or some other means. The complaint says nothing about whether the Laundries actually received that letter, so their lack of response is a far cry from outrageous conduct that goes beyond all bounds of decency. Furthermore, that the Laundries would not respond to a communication that may or may not have violated rules of professional conduct is hardly outrageous. Furthermore, the intent element alleged is insufficient as a matter of law. The complaint accuses the Laundries of acting with malice or great indifference to the rights of the plaintiffs. Complaint 30, however, Florida law is clear that acting with malice or indifference is not enough. Outrageous conduct is what is required, and the plaintiffs have not alleged it. Even if this court were to have reservations as to whether the Laundries' silence was outrageous, to permit this claim to move forward would trample the Laundries' constitutional rights. As discussed below, the Laundries' conduct was legally protected and cannot form the basis for an intentional infliction of emotional distress. Oh man. You know, what I learned here is to not convey any amount of empathy or sympathy in legal documents, right? Because that's kind of where they're nailing them here. By saying, we understand it was a difficult time and you were just trying to protect your son. Ooh, they've really honed in on that. 2. The Laundries are entitled to exercise their legal rights. At its core, the complaint is critical of the Laundries for refusing to respond to either Joseph Petito and Nicole Schmidt or law enforcement. However, compelling individuals to respond to inquiries by private citizens or law enforcement through a civil action like this would turn our entire constitutional system and the freedom afforded individuals in this country on its head. The plaintiff's suit, founded on their thoughts or position on what they wanted the Laundries to do, infringes on too many fundamental rights to be discussed in this motion, but the exercise of even one right is sufficient to defeat a claim for intentional infliction of emotional distress. From the first recognition of the tort of intentional infliction of emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would otherwise be extreme and outrageous, may be privileged under the circumstances. The actor is never liable, for example, where he has done no more than to insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. Finding as a matter of law that alleged facts were not outrageous where the defendant did no more than assert legal rights in a legally permissible way. This principle has been upheld many times since. And then they say a convenience store called the police to have a 6-year-old shoplifter arrested. An act of the court was found to be clearly within the store's legal rights. So they gave an example there. They say if the complaint is supposed to establish outrage based on the carrier's insistence that the employee conduct a job search, any allegations showing that the carrier's conduct was extortionate, unprivileged, unlawful, or fraudulent are wholly missing. Giving some other examples. The Laundries had a legal right to do or not do everything described in the complaint. The Laundries are entitled to the right of freedom of thought protected by the First Amendment, against which includes both the right to speak freely and the right to refrain from speaking at all. The right to speak and the right to refrain from speaking are complementary components of the broader concept of individual freedom of mind. The clear implication has been that any such compulsion to publish that which reason tells them should not be published is unconstitutional. The Laundries have a general constitutional right to not speak on any topic, and a more specific constitutional right to not to speak in the face of a criminal investigation. There was unquestionably a law enforcement investigation of the Laundries regarding the disappearance of Miss Petito, and the Laundries had and still have an absolute right to remain silent. For the Laundries to exercise their constitutional right to refrain from speaking and to instead hire an attorney to speak for them is not only common practice in a civilized community, but it embodies the exercise of fundamental rights under the United States and Florida constitutions. Both the United States Constitution and the Florida Constitution indisputably permit retention of an attorney, and on occasion they require the government to provide the services of an attorney. And they give another example: the citizen's right to consult an independent lawyer and to retain that lawyer to speak on his or her behalf is an aspect of liberty that is priceless. Florida provides an even broader right to counsel than is provided by the Sixth Amendment. The right to effective assistance of counsel, as agreed by the 6th and 14th Amendments of the United States Constitution and Article 1, Section 16 of the Florida Constitution, is among those immutable principles of justice which inhere in the very idea of free government. Yes, okay. In addition to the federal Sixth Amendment right to counsel, there is also a long recognized First Amendment right to hire and consult an attorney. We recognize the right to hire and consult an attorney is protected by the First Amendment's guarantee of freedom of speech, association, and petition. The right to retain and consult an attorney implicates clearly established First Amendment rights of association and free speech. along with the protection afforded by the First, Fifth, and Sixth Amendments to the United States Constitution and similar provisions in the Florida Constitution regarding speech and legal representation. The Laundries also have federal and state constitutionally protected privacy rights. The Due Process Clause of the 14th Amendment protects individuals from state intrusion on fundamental aspects of personal privacy. And they give some more examples again. Wow. Florida, I think they've got a point though, right? The Laundries didn't have to talk. This is the worst thing. They didn't have to say anything according to the law. Put simply, the Laundries have fundamental constitutional rights to silence, privacy, and representation by counsel, but the Laundries' exercise of these rights is what the plaintiffs claim caused their emotional distress. The Laundries' rights are inalienable, and the Laundries can never be liable for exercising their legal rights in a permissible way. Thus, as a matter of law, the plaintiffs have not alleged any act or conduct on the part of the Laundries that would impose liability upon them, which would survive a constitutional challenge. 3. The plaintiffs must be present. The complaint suffers from another fatal flaw that is further evidence as to why there is no cause of action in this factual scenario. For conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff and in his or her presence. Ooh, this is hectic. They make very strong points here, you know. It's not nice. It's very ugly, this whole thing, but they're making legal points here, right? My word, let me know what you think in the comments below about all this. Then they're giving some examples here again. Wow. So they say, as set forth in the complaint, there was no contact between the Laundries and the plaintiffs after September 1st, 2021. If there was no contact, then the Laundries certainly could not have committed any act in the presence of the plaintiffs that would support a cause of action for intentional infliction of emotional distress. What happened to Ms. Petito is certainly unfortunate. However, as the 3rd District Court of Appeal reasoned, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. Number 4, causation and severity. The last two elements necessary to state a claim for intentional infliction of emotional distress require factually supported allegations that a defendant's outrageous conduct caused the victim emotional distress that is severe. The plaintiffs all but concede in the complaint that the Laundries did not cause the plaintiff's grief. The complaint alleges that the Laundries knew of the mental suffering and anguish of the plaintiffs and knew that they could alleviate, at least in part, such mental suffering and anguish by disclosing what they knew about the well-being and the location of the remains of Gabrielle Petito. By setting forth that allegation, the plaintiffs acknowledge that their mental suffering and anguish existed prior to and independent of the Laundries' conduct of remaining silent. Rather than alleging that the Laundries were the sole and proximate cause of the plaintiff's distress, in essence, the plaintiffs allege that the Laundries' silence failed to alleviate, at least in part, such mental suffering and anguish. Since alleviation can only come after the suffering is already being experienced, the Laundries' alleged failure to alleviate is not the sole and proximate or legal cause of the plaintiff's alleged injury. Stated differently, the complaint's own allegations contradict the theory that the Laundries caused the plaintiff's mental suffering and anguish. The complaint alleges that the Laundries were the direct and proximate cause of plaintiff's injury and also alleges that plaintiff's grief was caused by something other than the Laundries' silence. Which means, as both a matter of law and fact, the complaint fails to allege that the Laundries were the legal cause of the plaintiff's grief, and the complaint should be dismissed. The pleader is bound by his own allegations in the complaint. Oh man. In addition to the lack of support for the causation element, the complaint does not allege, let alone factually support, that the emotional distress was severe. The complaint spends most of its paragraphs discussing the Laundries and provides nothing beyond the conclusory allegation of mental suffering and anguish by the plaintiffs. The term severe does not appear as a description of the plaintiff's alleged injury. Where the elements of a cause of action are not pled, they may not be inferred from the context of the allegations. While the complaint alleges the plaintiffs were extremely distraught and desperately searching for information concerning their daughter, the complaint does not specifically discuss how the plaintiff's mental suffering meets the severity element, nor does it describe their distress as severe. The fact remains, however, that significant feelings of fright, shame, worry, and humiliation, and others besides occasioned by the acts of others are, even if regrettable, an unavoidable part of living in society. Thus, courts that have tackled this issue have recognized that a high standard for determining what kind of emotional distress is remediable in a claim for intentional infliction is necessary to prevent the tort from becoming a venue for litigation over every emotional injury. In sum, the plaintiffs have failed to satisfy the elements of causation and severity. The plaintiffs were understandably fearful about what happened to their daughter, and they would have been upset about their daughter regardless of anything the Laundries could have said. But that fear or sadness was not caused by the Laundries. It was an unfortunate, unavoidable part of the entire circumstances surrounding Brian Laundrie and Gabby Petito. Conclusion: the plaintiffs have not and cannot set forth factual assertions that can be supported by evidence which gives rise to legal liability. As such, this action for intentional infliction of emotional distress against the parents of Brian Laundrie, however inartfully drafted, is not legally sustainable, and the complaint should be dismissed with prejudice and without leave to amend for all the reasons set forth above. Wherefore, defendants Christopher Laundrie and Roberta Laundrie respectfully request the court dismiss the complaint with prejudice. Respectfully submitted, Trombley and Haynes, P.A., by P. Matthew Luca, Florida Bar number 0555630, Trombley and Haynes. Oh my word, attorney for Christopher Laundrie and Roberta Laundrie. Certificate of service. I certified that on March 30th, 2022, I electronically filed the foregoing through the Florida Court's e-filing portal system, thereby serving all registered parties, and served via email upon the following: Patrick J. Riley, Snyder and Riley, and there's the email address. And that, Grizzlies, is the document. See, that wasn't so bad, and it wasn't so long. I didn't even need to rest my voice that much. I mean, they do have legal points. That's the problem. The problem is, of course, with the Petitos filing the lawsuit. I think most of us are like, yes, let them go to court. Let's hear some more information. Let's see if more facts come out, especially to understand the timeline. For me, the biggest curiosity is still what on earth happened between even the 13th of August and the 23rd. Because Brian apparently went home from the 17th to the 23rd. I've even seen some speculations that he would have taken Gabby's van and driven home, been there for a day, and then driven back. No flights required. Like, whoa, that's a hectic thought. But, of course, we all would love to see justice for Gabby Petito. I don't know if that's going to happen with this lawsuit. It seems like this lawyer has made some very strong points to really dismiss that lawsuit. What do you think? Do you think that the Petitos will actually be able to counterfile and explain why things should continue? To me, it just feels like, wow, it is a legal system and not a justice system. I can't speak for all countries, and I am South African living in the Netherlands, but just law in general, criminal law, from what I've sort of seen worldwide, right? It's all based on legalities, which is a very ugly world to live in. Sometimes you got to defend some horrible, horrible things as a lawyer. And sometimes it might not quite feel like justice. So I suppose the best thing that we can do is to keep Gabby Petito's memory alive, to, honor her memory, think about how she lived and not really how she died, and focus on all this ugly law stuff that's going on around it. I think that's what we can do. I still have some Gabby Petito merch available if you want to grab some of that. It's got a beautiful butterfly on it designed by Panna Puma, who's on Instagram. I'll link that below as well. You can grab that merch. All the proceeds that I collect from that merch line, people are still buying it a little bit. So if you want to buy some now as well, any proceeds that we collect from there will be donated to the Gabby Petito Foundation. I know that they also help in other missing persons cases, either by promoting it, or I think from what I understand, their foundation is doing is to raise awareness for DV and to raise funds to help with those types of situations. So that's one way that we could all, I suppose, wear, like I've got a pink hoodie with a butterfly on. Love wearing that. Love, and on the back it says Justice for Gabby Petito. So if you want to get some of that, that's one way we could do that. But other than that, really just supporting the family, sending them nice messages. They're still very active on social media. Of course, you can donate directly to the foundation, things like that. But yeah, this lawsuit, it seems like it's quite an ugly thing, don't you think? Anyway, thank you so much for those of you who made it all the way to the end. Please do leave your DNA on the thumbs up, subscribe, hit the bell so you know when I'm next either premiering, live streaming, or uploading. And I will see you in the next one.